Okay, this is like take 27. I finally got the camera position right. For those of you that don't know me, my name is Ted Visner, and what we're going to do here is create a documentary with regards to how I found myself at odds with the state of Michigan and its police officers and its lawyers and its judges. For those of you that are unfamiliar with the way things are going here in our courts and with our police, I'm going to start over from the beginning with the single issue that kind of put me, I guess, in direct conflict with the direction this country is being taken by the state bar, the national bar, its lawyers, its member lawyers, and the police and judges and prosecutors, and how they all are kind of working together right now to screw people over and screw them out of the rights. A lot of my friends tell me it's because of status. I don't agree with that. The presumption of my status as a state employee or as a U.S. citizen is basically an unfounded presumption that's not proven. There's some aspects that I agree with regard to that. There has to be an underlying reason, underlying cause that would pit me as an enemy of the state for trying to find justice in our courts. So in 2010 was a horrible year for myself and my family. My mom died in November 2010. That was a really rough time. But 2010 started a lot rougher than that. In April, a lender out of Grand Rapids by the name of Pinnacle Capital Group or Capital Fund or whatever hired a lawyer by the name of Winkler to take advantage of Michigan compiled law and violate actual Michigan compiled law to steal a house from my wife and I that had over $100,000 worth of equity. And I thought it would be a simple case to pursue myself because it was so clear. Essentially, this lawyer fraudulently recorded a deed in the name of his client, Pinnacle Capital Fund, and came to the property and used this deed as though it were some sort of eviction. And this was all done under the presumption of abandonment that had been properly refuted. So obviously the bank and the bank's lawyer didn't care about us properly refuting, as according to Michigan compiled law 600.3241A from memory. I think that's right. And essentially this Michigan compiled law, this 3241A, which is in Chapter 600, talks about the presumption of abandonment and what needs to be done not only by the lender but by the borrower to refute the presumption of abandonment. And I have it printed here, so I'm just going to read it really quick. This is in the Revised Judicature Act of 1961, and 600.3241A, abandonment of premises, residential property not exceeding 4 units, presumption. Okay, section 3241A. For purposes of this chapter, if foreclosure proceedings have been commenced under this chapter against residential property not exceeding 4 units, there is a conclusive presumption that the premises have been abandoned if all of the following requirements are satisfied before the end of the redemption period. Okay, now this law was obviously lobbied for and petitioned for by lenders, banks, on the grounds that they didn't want to have to wait for the expiration of a redemption period before they could reacquire the property. The goal of this law was to minimize the losses accruing on any individual properties that have actually been abandoned. So the law in and of itself makes sense to the extent that it's complied with all the parties, by all the parties. You know, if I was a bank and somebody had skipped out on their mortgage and didn't have any interest in the property and they'd left voluntarily, I would want to be able to get that property back inside of the redemption period. And essentially that's what this law does. It allows the lender to get the property back in 30 days. So that obviously would minimize losses, continuing losses by the bank for having to wait for the full redemption period. So, you know, to a great extent, it makes a lot of sense. I'm just going to continue on. We're in 600.3241A, and we're now on Section A. The mortgagee has made a personal inspection of the mortgaged properties, and the inspection does not reveal that the mortgagor or persons claiming under the mortgagor are presently occupying or will occupy the premises. Okay, the mortgagee is the bank, and the mortgagor is the borrower or the owner, and the bank is required to inspect the property, and that inspection must reveal that the mortgagor or persons claiming under the mortgagor are not presently occupying or will occupy the premises. Okay, we're on B now. The mortgagee has posted a notice. Okay, the bank has to post a notice at the time of making the personal inspection and has mailed by certified mail, return receipt requested, a notice to the borrower, the mortgagor, at the mortgagor's last known address, which notices state that the mortgagee considers the premises abandoned and that the mortgagor will lose all rights of ownership 30 days after the foreclosure sale or when the time to provide the notice required by Subdivision C expires, whichever is later, unless the mortgagor or the mortgagor's heirs or personal representatives or a person lawfully claiming from under one of them provides the notice required by Subdivision C that the premises are not abandoned. Okay, Subdivision C, within 15 days after the notice required by Subdivision B was posted and mailed, the mortgagor, the mortgagor's heir, personal representative, or person lawfully claiming under one of them has not given written notice by first-class mail to the mortgagee and an address provided by the mortgagee in the notices required by Subdivision B, stating that the premises are not abandoned. This is pretty easy to understand, and I just want to pull out a couple of things here. In Subdivision B, the mortgagee has posted a notice at the time of making the personal inspection and has mailed by certified mail return receipt requested this notice of abandonment. Okay, this is the requirement of the lender. The mortgagee, the lender, has got to post a notice in a predominant place on the property, and this is not or, this is strictly and, so both of these items are specifically required. Mailed by certified mail, return receipt requested, the same notice of abandonment that the bank considers the property abandoned. So the bank is supposed to post a notice in a predominant position on the property, like the front door, and in my case here they did. The property at 1647 Franklin Street in East Grand Rapids, Michigan. The notice was posted on the door. The lender and the lender's lawyer never sent us any mail by certified return receipt request, and nor would they ever be able to prove that they did. So right off the bat in this case, with regard to our property on Franklin in East Grand Rapids, the presumption of abandonment cannot be applied here because they failed to meet the requirements of Michigan compiled law 600.3241A, which requires them. It's a requirement before the presumption of abandonment can be upheld that they have to do both of these: post the notice and mail via certified return receipt requested. Okay, now I'm going to skip to C because in the event that they forge or find whatever, produce the green slip, the certified return receipt request saying they mailed us something on the appropriate time and date, which would have been April 1st, 2010. Subdivision C says within 15 days after the notice required by subdivision B was posted and mailed. Okay, so the absolute presumption of abandonment had a 15-day provision in this same Michigan compiled law for us in this case to dispute the presumption. Okay, you can't just make a presumption and present it to somebody and then not give them the lawful time required to respond. So to figure out the day and the days, we have to do a little bit of math here. Now the law says 15 days after the notice was posted and mailed. So if the notice was posted on April 1st, then the 15 days start from April 2nd, which would make the deadline for us to rebut this presumption midnight of April 16th, 2010. This is very important because this numbers thing is majorly important. And this Pinnacle Capital Fund hired Winkler, I forget his first name right now, to do all of this and to make it look and appear like the bank would reacquire possession of our property on April 15th. Now, April 15th was only 14 days after posting, and we still had a full day to rebut the presumptions. Now, in April 2010, the 15th fell on a Thursday, and coincidentally, we had till midnight on Friday, April 16th, to rebut these presumptions, which means that the bank and the lawyer, had they properly waited for our time to reply, to respond to these presumptions, would have only been able to record a new deed on Monday, April 19th. We had till Friday at midnight to rebut these presumptions. We rebutted them on and before Thursday. We actually hired a lawyer in Grand Rapids that paid with our $1,200 or whatever we paid him. He hired a messenger service to actually hand deliver notice that the premises at 1647 Franklin were specifically not abandoned. The same lawyer made multiple phone calls and talked to these people, telling them that the property was not abandoned. But on April 15th, we knew this was going to happen. We knew that the bank wanted this house back because it had over $100,000 worth of equity. Now, we bought the property as an investment. Okay, we bought the property for $44,500 or something like that, and we put about $100,000 in labor and materials into finishing the property, and got it to appraise northwards of $220,000. So there was a significant amount of equity in the property. Now the labor portion of this property was still due and owing to me. And when the house was stolen and we were not allowed to sell it, I never realized payment for my labor to fix the place up. The house was previously foreclosed 3 or 4 times before Kathy Smith and I bought it, and the last owner had actually jacked the house completely off the foundation, tore out the Michigan basement, and put in a new cinder block foundation and a new gas furnace, and et cetera, et cetera. So when we bought it for $44,000, we recognized that we were getting a hell of a deal, and the fact that I am and have been a builder for my entire adult life, didn't see that as a problem to buy a house that was floating in midair. it hadn't been set down on the new foundation. It was kind of in between when we got it. But not to get too far off topic, the lender in Grand Rapids, Pinnacle Capital Fund, was a hard money lender. We understood and appreciated that. We wanted to borrow quick and pay off fast. And we had a buyer for this property before they stole it from us. And we had moved the buyer into the property on or about April 1st as a renter until his loan could close. So the property most definitely was not abandoned. The renter buyer was moving stuff in. He was basically shopping for different mortgages. It was very important for him to have a property in East Grand Rapids. The house across the street was appraised, or not appraised, but valuated according to Zillow over $650,000. The house next door was a similar value according to Zillow. So we basically bought the worst house in the best neighborhood in East Grand Rapids. It was in the East Grand Rapids School District. Very, very desirable home. We converted the home from a 3-bedroom, 1.5 bath to a 3-bedroom, 2.5 bath. We took the kitchen out. We put the kitchen where the dining room was. We put the dining room where the kitchen was. We had hardwood floors throughout. We had a forced air gas fireplace on the main level. And we just really did a cherry job with this property, and the bank recognized the quality of our work and the fact that there was so much equity in the property. And keep in mind, this is 2010, where valuations were fluctuating like crazy, and they wanted it. Pinnacle was in their own financial straits at this time, and they were being accused of securities frauds and violations, etc. And they wanted to realize the equity that we had in the property, and I believe that's why they did what they did. Now, they hired a lawyer by the name of Winkler, who recorded the deed on April 15th when we had through April 16th to rebut the presumption of abandonment. And I think it's really important to show you guys here and to explain what we're doing. Now, on April 15th, when this lawyer Winkler went to the Register of Deeds in Kent County, had recorded a new deed for our property with his client's name on it, he brought this wet ink deed to the property. And like I said, I called the East Grand Rapids Police Department. There were 2 of them there. And Winkler showed this wet ink deed that he had just recorded in fraud to these 2 East Grand Rapids police officers. And you can imagine what the police officers thought and felt about seeing this, freshly recorded deed. They didn't know how fresh it was. They just saw that the property was now deeded to the bank and that I was, in fact, the imposter. And the police apologized. They said, "We feel for you, but really there's nothing we can do. This guy's got a deed." So right now what we're going to do is reverse engineer this entire problem from 2010, because the fact that this lawyer did what he did through fraud, there are no statute of limitations on fraud, so we kind of backburnered this. But in light of recent events and the events that have transpired against my family, including the theft and loss of 2 more properties by the Isabella County Sheriff's Department in fraud, what we're doing is we're drawing a line. We're enveloping everything that's happened into a single scenario to demonstrate how us having named this Winkler in our original complaint in 2010 has evolved into a protection and preservation of not just lawyers and the bar, but the state and the state's interest and self-preservation efforts to preserve the public trust in these things that are going on with our courts, with our judges, with the lawyers. So, having named this lawyer in the claim originally is believed most wholeheartedly to be the reason and the cause for us being under the gun in every scenario that's happened since 2010. And what we're going to do is we're going to present an affidavit to the East Grand Rapids Police Department. We're going to make these charges and allegations as criminal frauds against my family, and we're going to ask them to get involved. Now, it was the East Grand Rapids Police Department that responded to my 911 call for assistance that said they couldn't do anything because of this freshly recorded deed. But now we're going to go talk to the chief of the East Grand Rapids Police Department, and we're going to show him the recorded deed. We're going to show him Michigan Compiled Law 600.3241 Alpha, and we're going to explain to him that this deed was recorded in fraud by Winkler, and that it had the specific intent to deprive us of our constitutionally secured right to due process. We had 15 days. This is Michigan law. That's our due process. Our due process was violated when Winkler showed up on the 15th with this fraudulently recorded deed that he had recorded that morning on the 15th, when we had through the 16th to rebut the presumption of abandonment. Now, you can see kind of how cloudy this got right out of the gate, and this is what gives bar attorneys and judges and everybody else kind of this carte blanche okay to do whatever they want to do, because you know it's very easily misunderstood by the people. So it's our intent, our focus, and our goal here to kind of cut the fat off and just show you what actually happened that allowed this bar attorney to steal a piece of real property with $100,000+ worth of equity from my wife, Kathy Smith, and I in 2010. Now, Kathy Smith and I obviously are no longer together. And that's not even really important here, but what's important to know, people that are following me know I just had a baby, and everything's copacetic there. In fact, yeah. But anyways, just to kind of explain from that perspective, Kathy and I were together in 2010. We owned this property together. I fixed it up, and it was in her name, and it was actually a project of ours. Like at the time, we actually owned 6 or 7 different pieces of real property, and this was just one of them. We bought it together. It was put in her name. I did all the work, and then we sold it, and we had the profits we would spend collectively, or so on and so forth. So what we're going to do is I'm going to read this really quick. This is a work in progress. We're presenting an affidavit of truth along with a claim for criminal fraud, and this is really quite simple. This in part is what's going to be presented to the East Grand Rapids Police Department. On April 15th, 2010, Attorney Winkler fraudulently recorded a new deed on the real property known as 1647 Franklin Street in East Grand Rapids, Michigan. Attorney Winkler had no lawful authority to record this new deed. This newly recorded deed was then used to steal the real property named above from Kathy Smith and Theodore Visner. Fraud is a crime for which there are no statute of limitations. Possible defenses to these criminal actions: number 1, stupidity; number 2, abandonment; number 3, open criminal acts under color of law; number 4, a mistake. Stupidity is no excuse. That's the answer to stupidity. Abandonment. The property was not abandoned, and your own police report dated April 15, 2010 will verify this, and the fact that your officers were shown the fraudulent deed. Under the abandonment laws of the state of Michigan, the presumption of abandonment is supposed to give the borrower 15 days to rebut the presumption of abandonment, and the deed was fraudulently recorded within those 15 days. Criminal fraud perpetrated by an officer of the court is done these days without fear of prosecution, and cops typically side with the lawyers and the bar. Winkler has had no fear of being charged with perpetrating this fraud. Mistake is not, I got a typo here. Mistake or not, the willful criminal actions of Winkler resulted in the loss of this property to Smith & Visner that had over $100,000 worth of equity. Winkler was compensated by his client to perform these criminal acts against Smith & Visner, which transferred the home and its equity to his client's Pinnacle Lending Group. If I were to go to the East Grand Rapids Register of Deeds and transfer ownership of the East Grand Rapids Chief of Police's personal residence to my own name and then kick him and his family out, this would be immediately understood and recognized as a criminal act. If I were to hire and pay a lawyer to do this for me, this would not convert this criminal act into a civil issue. Winkler will claim that Michigan law was properly applied, but will be completely unable to prove it. Winkler used the presumption of abandonment laws in the state of Michigan to steal our East Grand Rapids home, knowing or believing that the police would not help us. And I printed Merriam-Webster's 1928 definition of fraud. The simple definition of fraud: the crime of using dishonest methods to take something valuable from another person. It was dishonest of Winkler to create and record a deed when we still had a day and a half to rebut the presumption of abandonment as required by law in MCL 600.3241A. That was dishonest. The result took our home at 1647 Franklin with $100,000 worth of equity and gave it to Pinnacle Lending Group.